Again, good afternoon to everyone. On behalf of all of my friends, colleagues, and partners at Conn Maciel Carey, we're very pleased that you are joining us today for this webinar. This is the fifth in a series of 12 monthly webinars that we will hold for our clients and friends. And I'm particularly interested in being part of this and pleased to join my good colleagues and friends, Lindsay DeSalvo and Bita Lascari, to talk to you today about OSHA rulemakings and the priority of the Biden administration, the various priorities the agency has on the rulemaking side of the House. Before we begin, why don't we do just a very brief introduction, because we want to use our time very effectively today. We've got lots of material to cover. But just very briefly, I'm Kate McMahon. For those of you who don't know me, I lead our rulemaking practice at Conn Maciel Carey, among other things, and have worked with OSHA in some form or fashion over, all I will say is over at least the last decade. I will not divulge any further information about how long I have been doing this, but I've worked with OSHA, I believe, on virtually every significant chemical rulemaking since the HAZCOM rule in the early 2000s, and have been keenly involved on behalf of key stakeholders in those rulemakings. I would like today to share not only some information about how the rulemaking process works, but I hope to give you some insights based on my experience working on these rulemakings. I'm joined by my colleague, Lindsay DeSalvo, and by my colleague, Bita Lascari, who will introduce themselves now, and then we'll get right to it. Lindsay?
Thanks, Kate. Hi, everyone. This is Lindsay DeSalvo. I am a partner at Conn Maciel Carey in both the firm's workplace safety practice and employment practices. I don't have quite as extensive experience as Kate does on the rulemaking front, but I have had the opportunity to participate in a few of the rulemakings from the Department of Labor on both the employment side, like wage and hour, changes to the FLSA and its interpretation, as well as on the OSHA side, and have actually been very involved in our firm's efforts related to the E-Recordkeeping rulemaking. So that is the perspective that I'll sort of speak from today. My experience in sort of the early rulemaking process up and all the way through now where we are with the E-Recordkeeping rule, which is at the final rulemaking process or final step in the rulemaking process. And with that, I will turn it over to Bita.
Hi, everyone. My name is Bita Lascari. I'm an associate in the Workplace Safety Practice Group. Before joining the firm, I was an attorney investigator at the U.S. Chemical Safety Board. And I have assisted Kate and Lindsay on numerous rulemakings, and most recently, probably most heavily involved in the heat illness prevention rulemaking. So with that, I'll pass it back to Kate to set forth the agenda.
All righty. All right, everyone. Well, thank you so much. Let's get right to it. Like I said, here's our agenda for today. We are going to spend the bulk of our time talking about the activities of the agency and the focus and priorities the agency has on rulemaking. I'm going to begin by, before we get to the hot topics, by just giving a little background on how rules are made at OSHA. You know, I was trying to think, everyone knows this saying, legislation is making legislations like making a sausage. So I was trying to think of the analogy for making a regulation, which, by the way, isn't even a regulation. OSHA's regulations, what we call regulations, are actually standards. And I'll talk about that in a minute. But you know, if making legislation is like making sausage, I feel like making regulations is like making sausage and then turning it into a brisket and letting it, you know, cook in its juices for, I don't know, 24 hours, but in OSHA world, that's, you know, years. And then putting it out back in the smoker and letting it smoke for a number more years. So it takes a long time to make an OSHA regulation, much longer than it typically takes to make legislation. And I want to give you guys a flavor for what happens during that time. But we won't spend too much time on that because we have a lot of priorities to cover. This administration, as I think we said in our introduction to our webinar on the calendar invites you all got, this could be the most active time that the agency literally has ever had in terms of rulemaking. It also may be one of the most active times they've ever had on the enforcement side of the house. And that has to do with the leadership at the agency and at the Department of Labor. So we'll talk about that. But the key priorities right now that OSHA has for rules are heat, e-record keeping, update of the lead standard, a new standard that not many folks know about, which is this union walk-around rule, and workplace violence. On the infectious disease side, OSHA has not completely killed, officially and formally anyway, COVID-19 rule. And so Beat is going to talk about that, but talk also more broadly about the infectious disease standard, which I think is likely going to be the standard that moves forward rather than a narrower COVID standard to address infectious diseases in the workplace. And then we're going to at least touch on some other priorities, maybe lesser or longer term, but still very key priorities for this administration: PSM, LOTO, HAZCOM, and emergency response. So there we are. Why don't we begin with what I think is the really, really interesting part of what OSHA does. You can divide OSHA into basically three groups: the enforcement side of the house, which all of you probably have dealt with in one form or another over the years. And we're all the part of the agency that we never want to deal with. The cooperative programs part of the house, the VPP and SHARP and compliance assistance and all the parts of the agency that help employers ensure that they are complying and or doing better than complying with the regulations. And then the standards development side of the house. And this is the side of the house that really not many people focus on or are aware of. This is true sort of, inside baseball, Washington, D.C. stuff. And it's the stuff I particularly have an interest in and have spent a lot of time over my career working on. It's the development of a standard. I mentioned a few minutes ago that we call these things regulations. What's the lockout tagout regulation? What are the guarding regulations? What are the ladder regulations? Actually, technically, these are all standards that are promulgated under a particular part of the OSHA Act. That's section 6B of the OSHA Act in conjunction with the Administrative Procedures Act. Both of those acts, section 6B of the OSHA Act, as well as the APA, the Administrative Procedures Act, essentially set out the path, the guardrails, the instruction sheets for how to promulgate an agency rule, including, of course, an OSHA rule. Now, the standards are the part of the agency that develops these standards is called appropriately the Directorate of Standards and Guidance. Currently, it is run by a fellow named Andy Levinson, a good and longtime employee of OSHA. And Andy is now the director of that directorate. His deputy is Lisa Long, also a longtime OSHA employee. Maureen Ruskin, who many of you probably know, has retired recently, so she's no longer within that department. So those are the folks who are at the top of the org chart in terms of the department within OSHA, the directorate that develops these rules. We have, very constructive relationships with the folks at OSHA who develop the rules. And the reason I'm taking just a little of our time to talk about this and the sort of the process is because many people don't get involved in the process. The first time a lot of employers know about a rule is when it is a final rule in the Federal Register or appears as in the CFR, the Code of Federal Regulations. From our perspective, that is far too late down the road to become aware of a rule that will affect your facilities, your industry. We like to work with our clients and key stakeholders in the development of the rule. This whole rulemaking process is filled with opportunities at every stage of the process to involve yourself, and with the goal and objective of influencing the outcome of that final rule that ends up mandating what you can and cannot do in your workplace. So it's a tremendous opportunity that is available. And we work, as I said, constantly with OSHA on the development of the rules that Beta and Lindsay and I are going to talk about in just a few minutes. Just a little bit more background. This rulemaking chart, this is an OSHA chart that's on the screen right now, and I really like it because it shows you how impossible this rulemaking process is, and it shows you how long it takes. I have highlighted on the left side of the screen some of the key sort of pivot points or pinch points of the rulemaking process that are key to stakeholders wanting to influence the outcome of a rule. First, there's either the advance notice of proposed rulemaking or the request for information. Before OSHA ever develops even a proposed rule, let alone a final rule, they will often develop an advanced notice of a proposed rule, which is essentially sort of a draft rule and or a request for information. Either of those documents are put out to the stakeholder, to the regulated community, to publicly, and OSHA solicits comments and or asks questions about the subject matter. So they can take that information and go back and do their sausage making and their brisket making and their smoking and make a rule, right? Well, that's where we should be putting in, industry, employers should be putting in important information to the agency to have them understand the constraints, the limits, the obligations they have in the workplace, and what they're already doing to keep their workers safe. Then there's the SBREFA process, another key phase of the rulemaking process. The SBREFA process I won't go into now. I think, sometimes we'll do a whole webinar on the SBREFA process, but it is the Small Business Regulatory Enforcement and Fairness Act that drives this process. That's what SBREFA stands for. And it basically gives small business an even special and unique opportunity to weigh in on the impacts of a rule on the small business community. There's OMB review. A lot of folks don't know about this, but OSHA cannot promulgate a rule. They cannot even propose a rule without first getting the White House to sign off on it. And of course, OSHA is part of the executive branch, but that doesn't mean that the White House is sitting there working with OSHA throughout the rulemaking process. Before it goes out to the public, it goes to OMB. You, as a member of the public, have an opportunity to engage with OMB separate and apart from engaging with OSHA. That's another key stage in the rulemaking process. And then there's the notice of proposed rulemaking. That's the proposed rule that most of you all, know about, and everyone writes comments on, and we always draft comments for our clients, and you have to draft comments on the rule. But before you get to that proposal, I can guarantee you, if you involve yourself early on, even before the ANPRM, and we'll talk about that, separately, if you have any interest in this, like I do, that's where you really have impact. Proposed rule is an APA animal. You have to put this rule proposal out there and allow those who could be impacted by the rule to provide comment on the rule. And the agency has an obligation under both the OSHA Act as well as the APA to address all significant comments issued. OSHA often, in fact, virtually always, will also hold a public hearing, although technically it really isn't required by the OSHA Act, but they will if someone asks for one, and someone always does. And so that's another opportunity. There's OMB review on the revised, rule that comes out of this proposal after all these comments are submitted. And then finally, there's a proposed rule. Could take as short as 5 years, could take as long as 12 years. It's plenty of times taken longer. It took the agency over 25 to make the revisions to their walking working surfaces rule. So lots of time, lots of process. And the reason, all this process that shows up in all these colors on this chart, those are not all required by the OSHA Act or the APA. But OSHA, because they get sued on almost every rule that they promulgate, has developed these little subparts, ironically enough, in order to insulate themselves on the back end from litigation, because they were getting sued by either labor or industry for every rule, and sometimes by both. Therefore, they've built in all these little sub pieces, and every single one of those almost is an opportunity for us to influence the agency, to speak directly with the agency, and share with the agency or the groups that are working with the agency, like, for instance, the advisory committees. That's not even on here. But OSHA, there are, as I'm sure many of you know, the National NACOSH and MACOSH and all the different advisory committees that are set up pursuant to statute to advise the agency. NIOSH, the sister agency, all those entities are also entities that we as stakeholders can interact with, interface with, and share information with in order to funnel it through to OSHA. All right, so that's 5-10 minutes on the rulemaking process. Now let's get to what you guys probably want to hear about, which is, okay, so with all that, what is OSHA actually doing now under this administration? Where are their priorities? We just put a slide together, just a copy of the agency's regulatory agenda, the most recently issued regulatory agenda. OSHA had the executive branch issues twice a year, in the fall and in the spring, theoretically anyway, a regulatory agenda that lists every rulemaking that is anywhere in the process, from pre-rule to proposed rule to almost final rule. This right here is the most recent Biden administration, Secretary Parker administration regulatory agenda. We don't have one yet for the spring. I hope we see one soon. All of those rules, what I just talked about, all the process that agency has to go through, the agency has to go through all that process for all of those rules. But we're not going to talk about all those rules today. We're going to talk about the key rules. If you asked me in the summer of 2021, a few months into the Biden administration, or if you asked the, at the time, Deputy Assistant Secretary Jim Frederick, who Secretary Parker was not, Assistant Secretary Parker was not there yet. Jim Frederick, as deputy, was running the agency at the time. If you asked him, okay, give us your top 10, pretty sure I've got this pretty close to accurate. I know that COVID-19 would have been at the very top. And all of these rules would have been on it. Since then, there's been a shifting. The world has changed. Some say COVID is over. President Biden, it's not what it was in September 21. So that has kind of moved around in terms of priorities. But I think you could still probably put infectious disease in the top 10. And the permanent COVID-19 standard for healthcare anyway remains on the top 10. We've highlighted those that we're going to talk about today, and we're about to do that because I think these now are the top priorities for the administration. And heat illness and the new e-record keeping are top among those. So why don't we get to it? And Beta, I think you're going to talk about heat.
That's right. Thank you so much, Kate. Okay, so heat illness rulemaking. So this is definitely, as Kate mentioned, a top priority for the agency. I think, fueled in part by warming summers we're experiencing, as well as the number and more extreme heat waves that we've been seeing too. So this would be a brand new standard for the agency. OSHA has enforced violations related to heat hazards under its general duty clause, which is sort of a catch-all provision. But the general duty clause citations tend to be a bit harder for the agency to prove. And some of the heat illness general duty clause citations have been successfully challenged by industry. So I think OSHA thought it would be a good time to get a specific standard on the books. So on October 27, 2021, OSHA issued an ANPRM for heat injury and illness prevention for both outdoor and indoor settings. Certain state plan states have heat illness prevention rules, a couple of which are more recent, like Oregon, which is both an indoor and outdoor rule. And that seems to be the route that federal OSHA is going to. California has had their outdoor heat rule for a while and is now really picking up its efforts to issue an indoor heat rule. But back to Fed OSHA, in the ANPRM, OSHA was looking for stakeholders to weigh in on a number of potential elements of a standard, such as your written heat illness prevention programs, engineering controls like ventilation, administrative controls like changes to workloads or schedules, starting earlier in the day when the sun has not come out yet, or implementing work rest cycles. Of course, making sure water and other safe hydrating options are available, requiring employers to climatize workers. That's sort of a newer, I think, emphasis, but OSHA's been mentioning acclimatization very, very often. And what that refers to is just gradually allowing the body to adapt and tolerate higher levels of heat stress. OSHA and NIOSH have historically recommended this rule of 20% for acclimatizing workers, and that was mentioned in the ANPRM. And basically what that means is under this rule, it's, workers would only work 20% of their normal duration of work on their first day in hazardous heat conditions, performing job tasks similar in intensity to their expected work, and then increasing the work duration by 20% on each subsequent day until they're performing a normal work schedule. Other aspects of a rule mentioned in the ANPRM include training, of course, for both employees and supervisors, physiological, medical, and exposure monitoring, and emergency response plans. And our firm, on behalf of our employers' Heat Illness Prevention Coalition, submitted comments on these elements, all of them really, but focusing, as one of sort of a general comment, sort of an overall approach, really stressing to OSHA that the standard really should be performance-based and flexible, since there really is no one-size-fits-all approach to this hazard. So that was back in October. The ANPRM was issued, and then comments were due January 26, 2022. And since then, it's been sort of a number of NACOSH, and as part of NACOSH, sort of a subgroup, this heat working group, and they've been meeting very, very regularly. So we've attended or spoke at all of these. A note about the NACOSH heat work group. This group was formed really to help engage stakeholders and better understand current best practices and challenges in occupational heat illness prevention. So it's sort of a think group. It's getting together of minds, representatives from both management and labor, and trying to figure out what are sort of the elements that need to be addressed for heat hazards. After forming this heat working group, it was split into two subgroups. One of them was charged with sort of compliance assistance materials, and the other one was charged with looking at potential elements of a heat injury and illness prevention standard. So you had one kind of looking at, compliance, sort of guidance around heat hazards, and then the other one really focused in on the rulemaking. And what the group as a whole, the heat working group as a whole, is meant to do is to present recommendations to the full NACOSH committee. The full NACOSH committee has the authority to adopt all or some of the proposed findings and recommendations developed by the group, and to present those to OSHA. Alternatively, the full committee may just decline to make any recommendations to OSHA. So what we saw is the first subgroup got ahead of the second subgroup, and on January 10th of earlier this year, presented their recommendations to the full NACOSH committee, and then that full NACOSH committee unanimously approved to send those to OSHA without changes. So OSHA already has sort of those compliance guidance material recommendations that were formed, that were created by the first subgroup. Those have already been sent on. And now where we're at is the second subgroup has moved to present its recommendations in front of the full NACOSH committee. And they did that on April 27th, and then they're going to present those to the full NACOSH committee in just a few days on May 31st. And we'll get into, more of what the second subgroup is recommending on the next slide, because I think that is the subgroup probably that is probably the more important or higher stakes subcommittee. But, I just also want to mention before we get on to the next slide that we're also in the SBRIFA phase of the rulemaking as well. OSHA has stated publicly that they intend to initiate the SBRIFA panel process for this rulemaking in early May. So the process of identifying small entity representatives, or what we call SIRs, is going on as well. Alrighty, so getting back to the second subgroup's recommendations for heat injury and illness standard, these are offered as considerations, best practices, and resources for OSHA. And as you can tell, they look a lot like what was in the ANPRM, right? First, having a written program or plan. They said as part of the plan, they want to see a hazard assessment and a bunch of other things, controls, procedures for high versus extreme heat. That's something a few state plan states have as well, sort of this distinction between sort of high heat versus extreme heat. Procedures for emergency preparedness and response, of course, having a plan administrator, right? Someone responsible for administering and enforcing the plan, that the plan be reevaluated every so often, and having employees participate in the development of the plan. The second part is, no surprise, right? Employee and supervisor training. We've listed some of the topics that the subgroup recommended OSHA include in a training requirement. They also mentioned that training should be available in different formats, such as, using graphical representation, adult learning methods, and sort of culturally appropriate references. I think there's an awareness that training needs to be understood, right, by the employee population. It can't just be provided, it must be understandable. And also just, that there should be initial and reoccurring training. So, an annual training, maybe in the springtime when temperatures start warming, and then maybe upon entry and re-entry, and then with maybe even smaller refresher trainings every several months. The group also touched on environmental monitoring, and while they did not prescribe a specific method or triggering temperature threshold, like 80 degrees heat index, which is that 80 degrees heat index has been referenced in a few OSHA documents. So that was something we commented on in our coalition comments, was just having a specific temperature threshold really doesn't seem to work, because 80 degrees heat index is, might mean something in one part of the country, but something very different in another part. So so it was good to see at least that that the working group didn't at least there specify a specific, didn't specify a temperature. They did sort of recognize, as you'll see as one of the in the sub bullet, that there needs to be some consideration of variability. So going to the next slide, then, workplace controls, of course, things like engineering controls, right, ventilation, work practice controls, and administrative controls, as well as PPE, so things like cooling vests. So again, just looking at a lot of the sort of topics that were addressed in the ANPRM, coming back in NACOSH's recommendations. The group also touched on acclimatization. I mentioned that already, even though I don't believe they specified like a rule of 20%. They did mention work hardening programs, which is basically a program to increase the intensity of work gradually over 7 to 10 days. So again, not as prescriptive, but still some recognition of the need for acclimatization controls. Also return to work procedures that apply, not just to new workers, but also workers who have been off or not working in the heat, and then exposure monitoring and observation, and accounting for sudden heat waves, and having plans to address those. So this is just a very high overview, but I think we are really going to see a lot of movement from OSHA in the next couple of months, as it, assuming the full NACOSH committee approves these, gets NACOSH's recommendation and starts the SBREFA process. And again, we want to we can't overemphasize really the importance of this phase of the rulemaking. This is where OSHA essentially sets the foundation for its standard. As the agency gets closer and closer to a proposed rule, it becomes more and more difficult to shape the contours and contents of the standard. So advocacy now can really have a significant impact on the final rule. So with that, I will pass it to Lindsay to discuss another top priority, e-record keeping.
Thanks, Pita. So before we get into the current status of the e-record keeping rule, we do want to start with a brief overview of the history and how it sort of developed. The e-record keeping rule came to be in 2016 during the Obama administration. And during that time, the specific requirements are what you can see here. First, employers with first establishments with 250 or more workers had to annually submit their 300 logs, 301 incident reports, and 300-day annual summary. So that was the initial requirement for large employers, the establishments with 250 or more workers. The second piece is establishments that had 20 or more workers in high hazard industries also had to annually submit data, but were only required to submit the 300-day annual summary data. So this was the initial version of the rule that came out in 2016. As part of the rollout of that rule, there were a couple other issues that OSHA addressed. First, that all of this data would be submitted electronically through a secure web portal, which is now their injury tracking application. And that's what employers have been using over the last several years to submit injury and illness data. And it did have some issues in the beginning that kind of plays into our concerns related to the current version of the e-record keeping rule, which I'll get into in a later slide. OSHA also said that it would attempt to scrub employee identifying information, because a really big concern around the original version of this rule, particularly its submission of 300 log and 301 incident report data, is that it would reveal employee personal and health information. So when OSHA finalized this initial version of the rule, it said that it would scrub any employee identifying information so that when they did publish the data, you wouldn't be able to identify individual employees. There was also an intent, as I just said, to publish the data in this initial rule, and that has actually gone forward. And then finally, OSHA had planned to use this data for enforcement targeting purposes, which we've also seen come to fruition over the last several years through their site-specific targeting program. Ultimately, however, the rule that actually went into effect was the version of the e-record keeping rule that came out during the Trump administration. After the e-record keeping rule was passed in 2016, there were several stakeholders in the industry that brought challenges to the data submission requirements, as well as the intent to publish the data and some of the new anti-retaliation elements that actually were incorporated into the e-record keeping rule. In response to that, in January 2019, the Occupational Safety and Health Administration under Trump issued a final amended e-record keeping rule that eliminated that requirement for large establishments, those with 250 or more employees, to annually submit 300 and 301 data. So that was a significant change, because that was, the 300-day submission was still something that, was going to be challenging for some establishments and would take some time to pull together and resources to pull together, and in some cases, substantial resources to pull together. But the real issue with this rule from an industry perspective was the large amount of data that would come from that 300 log and 301 incident report data. And so it was a significant change during the Trump administration to pull that back. So the current version of the rule only requires large establishments, those with 250 or more employees, to submit 300-day data on an annual basis. And similarly, for establishments with 20 or more employees in high hazard industries, they also annually have to submit the 300-day data. So that is the current version. That's what we've seen over the last 5 years, that there's only submission at this point of 300-day summary data. Notably, the rule that was passed during the Trump administration did not address the publishing of the data, nor did it address the anti-retaliation elements. So both of those requirements also still remain in the standard, but it was a really significant shift to take away the submission of 300 log and 301 incident report data. And that's something that the new e-record keeping rule may change, and we think likely will change. So how has the data been used so far? I already mentioned the site-specific targeting program that OSHA has used that has been updated to incorporate the new years of data as they come in. And basically, those of you participating in this webinar, a lot of you probably have heard of the site-specific targeting program, maybe have some experience with the site-specific targeting program, but that was a significant enforcement effort because all inspections conducted under the site-specific targeting program are comprehensive in nature. So a lot of times will result in citations if an employer is chosen for that specific type of inspection. Another way that OSHA used its e-record keeping data last year was in an enforcement program that basically took effect for the 6-month period after data was submitted in March of 2022. So during that time, what would happen is if an inspection was opened, an OSHA area office might compare that particular site against the requirements for e-record keeping submission of the 300-day data. And if it was found that for some reason the employer had not submitted the data as required, then that could be an additional basis to cite the employer under that particular regulatory requirement. So we have not seen a similar program launched this year, but that was just another way that OSHA has used the data that it's collected through the e-record keeping requirement for enforcement purposes. So the most important piece of this, I think, and probably what everyone really wants to hear about, is what's coming. So as I said, in 2016, the Obama administration published the original final e-record keeping rule, which was then significantly revised by the Trump administration. So then in March of 2022, OSHA, during the Biden administration, went ahead and issued a proposed rule that would expand the e-record keeping requirements significantly. And that rule went back to the form that had been passed during the Obama administration, and actually is even proposing changes in a way that would make the impact of the e-record keeping rule even more significant. So the first piece is that it does maintain the requirement for workplaces with 20 or more employees and high hazard industries to submit 300-day data, but it does revise the list of covered industries that is provided in Appendix A. And then even more significantly, it eliminates the requirement for establishments with 250 or more employees to submit the 300-day data, but replaces that with a new requirement for establishments with 100 or more employees in a new set of high hazard industries to submit not only the 300-day summary data, but also data from the 300 logs and the 301 incident reports. So two really significant changes there. First, dropping the size of the employers who are impacted by this to establishments with 100 or more employees, and then also adding this new set of high hazard industries which is much more expansive than what we saw in the original version of the rule. It includes a lot of industries, or at least several industries that were not originally included. And so we'll bring in a lot more establishments and have a very significant impact on the employers that are actually affected by this particular regulatory requirement. This rule, like I said in the beginning, is at the final stages, basically. As of April 7th, 2023, OSHA had proposed the final e-record keeping rule and delivered it to the Office of Management and Budget, which is the final step of the review process before the rule is actually promulgated. Currently, OMB is meeting with stakeholders. It is currently allowing stakeholders to request meetings. And as part of that request for meetings, stakeholders can submit as well written advocacy, exhibits, data, anything that they think would be helpful for OMB to consider in connection with their meeting. And the way these meetings usually work is, the representative of the stakeholder will meet with representatives of OMB and OSHA and have an opportunity to verbally advocate or discuss certain aspects of the rule and provide feedback to OMB before the final rule is ultimately promulgated. And we actually participated in one of those meetings on behalf of the coalition that we filed comments for related to this rule at the beginning of this week, and took that time to strongly advocate against including 300 and 301 level data, as well as expanding the scope of employers included in that data collection process. It is projected that a final version of this rule will come out in June 2023. And that is our expectation for several reasons. OSHA has said that that's sort of the target date. And based on ongoing litigation, that is also the target date. This slide just shows the new Appendix B. So the high hazard industries that would be included. Any establishment that falls under one of these NAICS codes with 100 or more employees would be subject to the e-record keeping submission on an annual basis and have to submit 300 data, 301 data, and 300A summary data. So just briefly, because we have some more topics we want to cover, so I won't spend too much time on this, but these are what we have identified as sort of the significant impacts of the amended rule. I already kind of covered the first one. Obviously, a significant amount more of employers will be affected by the rule. But what we see as sort of, I think, the biggest concerns related to the expansion of the type of data collected through the 300 log and the 301 level data is first that it could expose employee identifying information and medical information. As I said before, OSHA in its prior iteration of the rule back in 2016, as well as in the proposed rule that it put out in 2022, has said that it has technology that will scrub this data, but we don't know how reliable that technology is. If it's really just focused on employee names, then there could be other information on the 300 log or the 301 incident report that could still identify the employee, particularly if it's a smaller employer or a smaller establishment, and depending on the type of operations at a certain location. And then it also would take substantial resources on the part of these employers. I think, anyone who is already submitting 300A summary data knows that this adds an additional step at the end of the year to really ensure that all of the information is accurate. It's being given to OSHA, being made public. We want to make sure it's as accurate as possible. But spending that same amount of time with the data collected on the 300 log and the 301 incident report would take even more resources, even more time. And ensuring the accuracy of that would also probably take more personnel resources as well. And so, we think that it's a substantial burden on the employers affected without there being a very meaningful impact for OSHA, because the data from 300 logs and 301 incident reports are not as easy sources to aggregate and to use effectively for things like a site-specific targeting program as summary data provided through the 300A data that's already submitted. And then also one other thing I wanted to point out before I pass it on is that the high hazard industries that have been identified really, in our view, and I think in a lot of other people's views, don't constitute high hazard industries. The rate that OSHA is using to sort of set the standard for what constitutes a high hazard industry is really near the average injury rate for industries across the nation. And so setting it near an average does not really identify those types of industries that truly are high hazard versus maybe just slightly above the average start rate or the average total recordable case rate. OSHA hasn't pinpointed exactly what type of rate it's going to use to make that final determination. So those are some of the main concerns that we have. And with that, I will turn it over to talk about the lead rulemaking.
All right, everyone, this is Kate. I'm going to be really quick because we've got other fish to fry and other rules to talk about. So just very quickly on the lead standard rulemaking. One, as we're emphasizing, it most definitely is a priority of the administration. The big question, the $64,000 question, is whether federal OSHA, and by the way, Cal OSHA also has an ongoing active rulemaking going on the lead standard as well. Other states are also have been and or will be over the next few years, I suspect, actively updating their lead standard. The big question is whether this is going to be a little update, an important, a very, very important update, and one that I think is fairly uncontroversial, non-controversial, or a very significant update that is broad in scope and will be very, very controversial. I don't know how to answer that. I can't read these tea leaves. I think I have signs going both ways. But let me explain what I mean. The lead standard is one of the oldest 6B standards on the books. When OSHA promulgated it in 1978, they got sued every which way. And those lawsuits went on for years. But ultimately, the rule was settled at the one that, you all know, for those of you in metals industries and have to deal with the lead standard. OSHA has been very focused on this standard throughout all the eons of its existence, and had put on the books a national emphasis program to do enforcement on the lead standard in 2001. That remains on the books. So, and in fact, I've handled a couple of lead NEEP inspections in the last year. So it's an active emphasis program. Enforcement is high. And the folks at the agency right now, I think legitimately the leadership who have worked in metals industries are aware of the weaknesses of this rule. The weakness or a weakness of this rule is that it was promulgated at a time when I think the goal of OSHA's was to ensure that workers' blood lead levels remained below 40 micrograms per deciliter. At the time, the science indicated that 40 and below was essentially safe. So they developed, as part of the rule, provisions that there's a medical removal provision in the lead standard. As those of you who deal with chemical standards know, that MRP is not in most chemical rules, but it is in the lead rule. So workers have to be removed from their job where they have exposure to lead if they have exposures above certain levels. And our slide here shows you what those thresholds are, essentially above 60 micrograms per deciliter, or an average of 3 tests, or above 50 micrograms per deciliter. And in construction, it's, one test greater than 50 micrograms per deciliter. once that worker is removed from work, you can't return them to work until their blood lead levels are below 40 micrograms per deciliter, because that's what OSHA believed when this standard was promulgated in the 70s was the right number. Well, the science has evolved since then, and it's pretty clear. And I think I don't think we have dispute about that science. I think it's pretty clear that exposures below 40, blood lead levels below 40 still can pose serious risk to workers. So OSHA opened this rulemaking in order to focus on that provision, the medical removal provision and its corollary return to work provision, and is talking about very significant reductions on that front. Now, the question, of course, is, well, how low is low and how low is safe? And there's probably going to be some debate around that. But I have a sense that if OSHA adopts even a significant reduction there, it is not going to cause major havoc for industry. And I think by and large, it will be acceptable to industry. What is going to be much more controversial is if OSHA moves beyond lowering the medical removal threshold and return to work threshold, and focuses on and includes in the rulemaking a significant reduction of the permissible exposure limit, the lead in air exposure level that is allowed in workplaces that have lead, and or the action level. And there are a lot of signs, both what we're seeing in California, for instance, as well as the advance notice of proposed rulemaking that OSHA issued last year, on which we commented. I think the next page, Vita has there we go. Yeah. The advance notice of proposed rulemaking was issued, last June, and lots of questions, numerous of which focused on whether there should be a reduction in the PEL and how low that could be. California just moved forward very recently, over the last couple of months. In March, it moved forward to actually issue a proposed rule, and that proposal includes a very significant reduction of the PEL from the current level, which is the same in California as it is on the federal level, 50 micrograms per meter cubed, to 10 micrograms per meter cubed. So five-fold reduction on the PEL, and a reduction of the action level from 30 micrograms per meter cubed to 2 micrograms per meter cubed. So we're watching this very carefully. We are going to be engaging with the agency to talk through on behalf of numerous clients where they are going with this. And I guess that's about all I need to say about it, except to kind of circle back to this issue of, what are the limits on OSHA's legal authority here if it were to take a fairly dramatic action. And I think there's still some question about, it's one thing to lower the PEL, it's another thing to lower it to the numbers that OSHA is talking about, including an action level, to levels that I believe are above the detection limit, but maybe just barely so in certain cases. So I think the real question is going to be, does OSHA have legal authority to take that step? And one of the things I was saying earlier is that OSHA has built in all this process in order to insulate it from litigation on the back end once it promulgates a rule. Well, that process is focused on meeting the legal standards that they must meet to promulgate a rule under Section 6B. And Section 6B, at least for chemical rulemakings like this, has essentially a threshold that limits OSHA's authority to promulgate chemical standards to only those where the standard would, the hazard at issue would result in the suffering of material impairment of health. That's kind of a key phrase in the chemical rulemaking world. And so there's a question about, at what level would an employee suffer material impairment of health. And so that would get into risk issues and probably more pertinent to the metals industry, because I think there may be some science that indicates that the issue of risk is at that level is controversial, but certainly on the feasibility side, the other big area that OSHA focuses on and industry focuses on, which is the requirement under the OSHA Act to promulgate only feasible standards. And when when Congress said feasible, that's been interpreted by courts to mean economically and technologically feasible. So there will be a lot of debate if OSHA takes the more aggressive step here and focuses on a serious reduction on the pellet action level as to whether those proposed standards would be economically and technologically feasible. I think that's all I need to say about the lead standard. I really wanted to just give you all, we wanted to let you know that it's happening now, and it is time to be very keenly focused on it if lead is in your workplace. All right, with that, let me turn it over to Bita, I think. Is Bita going to talk? Yes, about COVID-19 and infectious disease.
Alrighty, so COVID-19 and the infectious disease rulemaking. As we know, the public health emergency ended, but still COVID-19 is a topic of interest for OSHA. And while we definitely think it's cooled down, it was probably priority number one when the Biden administration came in, right, as Kate mentioned. It is still on the agency's radar. OSHA is still opening COVID-19 NEP inspections, mostly on healthcare entities, but we think the rule will likely be combined and addressed by a broader infectious diseases rule. So with that, just a quick history. We had the Emergency Temporary Standard, or ETS, for healthcare that was issued on June 21st, 2021. And that was a comprehensive programmatic rule, right? It covered everything: COVID-19 plan, respiratory protection, physical distancing, cleaning, disinfection, ventilation, training, record keeping and reporting, all the things. The COVID-19 ETS was promulgated June 21st, 2021. And what happens is that ETS automatically became a proposed permanent standard. So the agency immediately took public comment on the rule in the summer of 2021. I think it was August 20th. And the rule remained in effect until OSHA announced that it was withdrawn, or I should say, not that it was entirely withdrawn, but that the non-record keeping / reporting provisions were withdrawn by the agency on December 27th, 2021. And that December date is not random. So under the OSHA Act, an ETS is effective until superseded by a permanent standard, a process that's contemplated by the OSHA Act to occur within 6 months of the ETS's promulgation. So December 27th was approximately marked, just a few days over the 6-month anniversary of the healthcare ETS. Another quirk is that even though OSHA announced the rule to be withdrawn, and when I'm saying the rule, I mean the non-record keeping, non-reporting provisions, it was not officially withdrawn due to some litigation that was initiated by various unions. So fast forward a few months later, on March 22nd, 2022, OSHA announced a limited reopening of the rulemaking docket in an effort to make the ETS a permanent rule. Comments were due April 22nd, and then a few days later, OSHA held a public hearing on April 27th to May 2nd. And we were involved in all of these. We submitted comments back in June, submitted comments in April, where we were involved in the hearing. But just let me pause here for a moment. What did that limited reopening of the rulemaking record tell us? Well, it looked like OSHA was actually contemplating removing certain scope exemptions, which was a big deal to many employers because there was one exemption where certain employers could be fully out of the standard if they screened and barred people from entering. So we formed a coalition which sort of developed into subgroups representing different sort of industry interests. And one of those groups where we were specifically focused on advocating to OSHA to maintain that exemption. What else? On a positive note, it seemed OSHA was contemplating aligning with current CDC guidance, which obviously the ETS's references had become old at that point, and also providing additional flexibility to employers. They were also considering tailoring controls to address interaction with people with suspected or confirmed COVID-19, emphasizing support for vaccinations, adding coverage, although in a limited way, to construction in healthcare. We, as part of our coalition, we address comments about that aspect. Making adjustments to the COVID-19 record keeping and reporting requirements, triggering requirements by community transmission level, and possibly accounting for new strains of the virus. And I think we had a question about, when the rules go to OMB, are the stages of the rules noted? And they are. So, for example, OMB on OMB-OR's website, it'll say whether the rule is in pre-rule stage or proposed rule stage, final rule stage. So there is a notation about that. So anyway, after the limited, actually after the hearing, things went pretty dark. We kept hearing from OSHA that the rule would be finalized in September or October of 2022, and then we had Secretary of Labor Walsh announce in June that would be finalized in 3 to 6 months, so meaning December at the latest. But also at the same time, we had that DC circuit in that union case said, basically saying that it had no authority to force OSHA to issue the rule. So a lot of times on OIR's website, they'll say if there's a sort of a legal deadline, that would be like a court issue deadline. So DC circuit saying it has no authority to force OSHA. We also had CDC watering down many of its guidelines, including source control masking requirements in September 2022. We heard President Biden unofficially, I think on 60 Minutes, state that the pandemic is over. And all of that really seemed to signal that maybe OSHA wouldn't be issuing a permanent standard. But then on December 7th, 2022, OMB-OIRA's website posted that they had received the proposed rule for review. So that was when we all thought, oh gosh, the permanent standard is just about to issue right near the finish line. And we actually thought that timing made sense because even though there are all these signs of sort of the pandemic slowing down and in the summer, we all know that the winter months, right, is when we see those peak number of cases. And, in the case of Omicron the year before, that was an enormous peak. So we thought OSHA was going to take advantage of the winter and that sort of peak timing. But as of today, the rule is still in OIRA's hands. And it's just been on the website posted that way pending review. So typically OIRA gets 90 days to review a rule plus an automatic one-time 30-day extension, so 120 days total. But there is this option for a regulatory agency to request an extension and no apparent cap on that. So since 100 days lapsed on April 6th, we think that's what's happened here is OSHA likely put in a request for extension. And that is where things stand. It's just still pending review on OIRA's website. But we do think that the more time that goes by, especially, with the public health emergency having ended, that it becomes harder and harder for OSHA to issue this rule, sort of given the changes in the pandemic. So, what that all means is, it might be picked up in that infectious disease rulemaking. I know Kate mentioned this. And in part because in the statement of need, you can see this on OIRA's OMB-OIRA's website. It specifically mentions COVID-19. I think I meant to bold that, but you can see right near the end there's a mention of COVID-19. And as you can see from the timetable, this rulemaking goes back a while, right? The RFI was issued May 6th, 2010, and SBREFA was initiated on June 4th, 2014. Then we had a change in administration, right, and the rule went dark. But OSHA is thinking about picking this back up, and with an NPRM expected to be issued in September of this year. So just a little, I know that was quick, but just a little bit of background on the infectious diseases rulemaking as well. And I'm going to hand it over to Lindsay now to discuss workplace violence.
Thanks, Vita. So the workplace violence rulemaking has been in effect for a while now. In July of 2016, there was advocacy and an actual petition to federal OSHA for a standard requiring a workplace violence prevention program. And in response to that, in December of 2016, OSHA issued an RFI to get information on a potential workplace violence prevention standard, specifically for the healthcare industry. And the responses to that were due back in April 2017. And right before the transition from the Obama administration to the Trump administration, actually on the last day that the Obama administration Secretary of Labor for OSHA was in his position, OSHA actually granted that petition to start the real work on developing a federal workplace violence prevention rule for healthcare. So the current status of that, I'll get into a little bit on the next slide, but you can see it's been in the works for a while, and there had not been a lot of progress on that. That was something, again, as Beta referenced, related to the infectious diseases rule. It went dark during the Trump administration. There was no real movement on it during that period of time, and then has been pushed forward to some extent during the Biden administration. And the fall regulatory agenda signaled a SBREFA process to begin in December of 2022, and that is what we'll address on the next slide. So in December 2022, there was an announcement of the intent to convene a SBREFA panel, and this is the process by which small business has the opportunity to provide information and feedback to OSHA on a potential rule. And it was actually, that process was actually convened on March 1st, 2023. So this process has already occurred, and it consisted of 5 teleconferences that were held in March, during which the panel that was convened, made up of OSHA representatives as well as others, met with small entity representatives to engage in a discussion about a potential rule and get some feedback on, what those small entity representatives understand they could see in a potential rule. So from there, the panel then develops findings and recommendations based on the feedback that was received during those discussions, and that has all been put together in a report. And that report will then be considered for the purpose of providing an actual proposed rule at some point in the future. And that timeline we're not really sure of yet. There has not been an updated regulatory agenda in a while, so that should have, some indication of the timeline that OSHA is looking for this, although as we all have probably experienced, those timelines do not always actually happen as provided in the regulatory agenda. They are often pushed further, but it does at least give some, idea of what OSHA is thinking as far as this next step in the rulemaking process. And this slide just shows some of the major recommendations that the panel had based on their findings and the information that they received from the small entity representatives during the SBREFA process. And those recommendations are recommendations that they've made to OSHA to consider in developing this proposed rule. Since we are getting short on time, I do want to make sure we get through our last couple topics. So really quickly, I'm going to just review the status of the union inspection rights at non-union workplaces rulemaking effort. So as many of you might know, back in 2013, there was a very controversial letter of interpretation that was provided that basically stated under 29 CFR 1903.8, which allows employee representatives as well as third parties to participate in an OSHA inspection in certain circumstances. And OSHA looked at that rule, and based on a request for an interpretation as to whether workers at a worksite that do not have collective bargaining agreement could designate a person affiliated with a union to participate in a walk-around inspection, they use the language of this rule to basically say that this would be permitted if the representatives are considered reasonably necessary and that they would make a positive contribution to the inspection in the opinion of the compliance officer. So this interpretation, industry felt and we felt moved away from the common sense reading of the regulation, which had historically been interpreted to only really allow third parties when they had some sort of technical expertise that would benefit a compliance officer during an inspection. So this was really outside the scope of how that standard had been interpreted in the past. As a result, there was a challenge, a legal challenge to that 2013 interpretation letter because it was so inconsistent with prior interpretations of 1903.8C. And it asserted that OSHA's interpretation effectively rewrote the regulation without OSHA having to go through the required rulemaking process, basically the whole process that we've been talking about today. So back during the Trump administration in April 2017, that letter of interpretation was actually rescinded. But recently in January of this year, the Biden administration announced that it was initiating a rulemaking to actually amend 1903.8C to basically memorialize that 2013 interpretation. So that process has started. There has not been an actual proposed rule yet, but they are trying to push that process forward. And the couple of concerns, there are several concerns, I think, related to this rulemaking effort, but the couple that we sort of see as high priorities is certainly that having an outside community or union activists in the work site during an inspection could definitely strain an employer's ability to cast their workplace in the most favorable light during an inspection, and potentially open up to a greater possibility of citations during an inspection. And also that with having non-union employers be required to allow a union representative on site during an OSHA inspection, that would certainly help with any organizing efforts on the part of the union potentially, and if nothing else, give useful information to that representative about the employer and how the employer works. So this one is still in the early stages, but it is at the proposed rulemaking stage. So we'll definitely be staying on top of this one and be putting out any information that we have as it develops. And with that, I will turn it back over. Oh.
Lindsay, if I could just add one point on this worker walk-around issue. It is the case, I think, that OSHA is following the proper procedure, setting aside any view as to the rule itself. Now OSHA is going through a rulemaking. In what they did under the Obama administration in issuing the interpretation letter, we don't have time in this webinar, we're already over a bit, to talk about interpretations, but I mentioned the office that writes rules, standards, is called the Directorate of Standards and Guidance. The guidance part of that title is, among other things, these interpretation letters. And that's a whole webinar in and of itself. But it is not in my view appropriate for OSHA to take such a dramatic step through the interpretation process, which is not a rulemaking process, and no parties have any opportunity really to know about and or comment on the nature of the change. So I think the agency under this administration is correctly pursuing a rulemaking on this, and it will provide all parties, both labor, unions, as well as non-unionized entities, the ability to provide OSHA their thinking and thoughts and information relevant to this. So with that, now let me circle back, and Bita, I think you're going to finish this up here, right?
Yes, I will round it out. So just the other rulemakings, I know we're already over time, so I'll touch really, really briefly on these, but these are other priority rulemakings for the agency. So So PSM, your process safety management, lockout, tagout, emergency response, and HAZCOM. And these are all current standards on the books. OSHA already has standards for all of these. So these are really just updates to those standards. It's not like heat illness, for example, which would be a brand new standard. Emergency response is sort of less so in one place. You've got, PSM is 1910, 119. Emergency response is a little bit scattered, but still existing standards throughout. And then you'll see we indicated where they are in the rulemaking. HAZCOM definitely taking the lead. It's at the final rule stage, and just circling back on Lindsay's comment about these timetables. So the dark blue sort of rectangles represent the timetables that have been posted per the fall regulatory agenda. I know there was a question about when the spring agenda will come out. I think that should, typically it's like late June, July. So that might be when we see the next one. But per the current one, at least you can see with HAZCOM, right? It indicated that in March, we would have a final rule. Obviously that has not been issued yet. So like Lindsay said, sometimes these tables are a little bit off, but they do indicate where OSHA will be, where OSHA expects or anticipates making some moves. So anyway, this is just, again, a quick overview of some other priority rulemakings. And with that, I think we'll close it out. Our next webinar will be on Thursday, June 8th, and that's preparing for and managing inspections. It's always a hot topic. Please check out our blogs. We write extensively on all OSHA topics, including all these rulemakings that you see here. And here's our contact information, and we're happy to answer any questions, in the chat. I think Teresa will be logging those, tracking those. And then, we're always happy to connect offline too, if you have any specific questions for us too.
One final thought, and that is to any of you out there who are going to be particularly affected by any of these priority rules. We actually do have coalitions that have formed for, I think, most of them. So please let us know if you're interested in participating with us in these coalitions to provide important and relevant data to the agency as they move through the rulemaking process. Thanks everyone for joining. And like Bita said, we look forward to you joining the next one on enforcement inspections.